of the Ames Zoning Board of Adjustment to order of Wednesday, October 13th, 2021. The Zoning Board of Adjustment is a quasi-judicial board created by the City of Ames. The board's purpose is to decide on applications for home occupation permits, special use permits, exceptions, and variances to the zoning ordinance. Applications for conditional use permits in the floodplain, requests for reasonable accommodation because of handicap, and appeals of the decisions of the zoning enforcement officer. As a board of the city, we welcome all testimony. We make our decisions based on the facts and evidence as allowed under city code and presented in open meeting. Testimony before the board must be given under oath or affirmation. If the proceedings become lengthy, we may ask that testimony be focused on new facts or evidence not already presented. We ask you come to the microphone if you wish to speak, so that your testimony will be audible and may be recorded. Before speaking, please complete an orange information card and hand it to our recording secretary. When you are testifying, please address your remarks to the board. We also ask that the proceedings be orderly. The Zoning Board of Adjustment is an independent volunteer board of citizens. We are not part of the city administration. We are served in our efforts by Jane Chang, Assistant City Attorney, Kelly Diekman, Planning and Housing Director, and Renee Hall, Recording Secretary. The order of proceedings for each application will be as follows. First, an oral statement summarizing the issues and procedural steps will be presented by the staff. Second, testimony and evidence will be presented by the applicant. Third, testimony may be heard from any members of the audience who wish to speak in support of or in opposition to the appeal. Next, the board will give the applicant and city staff an opportunity to present concluding summaries and arguments. And finally, the board will discuss the issues and evidence and come to a decision. First item on the agenda tonight is approval of the minutes of the meeting of September 8th, 2021. Are there any changes to the minutes? Hearing none.
Move approval.
Second.
All those in favor say aye.
Aye.
Opposed, same sign. The motion carries. Next item on the agenda is a request for a variance to allow the use of the existing 61-unit building approved as an independent senior living facility at 3709 Tripp Street as an apartment dwelling in the FSRM suburban residential medium density zone, and to allow less than the minimum number of required off-street parking spaces for an apartment dwelling. And this item is continued from August 11th, 2021. Kelly.
Yeah, good evening. So Ray Anderson, who first introduced this item to you in August, is unavailable tonight, so I'll be presenting the item. My understanding is on August 11th, you did not actually conduct the public hearing. I think we took the information in and we tabled it for future notice. So the item was rezoned, or not rezoned, I'm sorry. It was renoticed for tonight, so a new mailing was sent out for tonight. The variance as presented is for the property that's outlined in blue on the exhibit here. It's the same as the location map that you have. It's going to be a little complicated to follow if you're just starting to look at this today, because we're talking about the relationship of two apartment projects that the same property owns. They were permitted by the city separately. So the city looks at the property with the 61-unit senior housing facility on it separately from the Windsor Point apartment project that was permitted under a major site plan. So in Ames, within this zoning district, we allow for apartment dwellings as a use. Multifamily is an allowable use, but we have a building configuration limit of 12 units per building. We have an exception that if you are approved as an independent senior living facility, which means you're exclusively for occupancy by people that are over 55, then you can be allowed to construct a larger building, but you have to also use it for that purpose. So the configuration requirements for the building are a little different. To meet that definition, you have to have some lobby area and some common spaces and different things that kind of aren't always in apartment buildings. They're customarily, they could be as well. So this project was approved as a special use permit to have 61 units in it. It's a 3-story building, so it's quite a bit different in size than you can see the apartments in the area. The variance request is to allow for the occupancy of that structure with any type of tenant, senior, family, individual, whomever qualifies to rent that space. And per the special use permit, obviously it was approved to be used specifically for that use. And along with the configuration allowance to have larger buildings, the use also has a lower parking requirement than is normally required of an apartment dwelling. So it's down to 1 parking space per unit. So if the board was to find that there was grounds for a variance for the use, you would also have to find grounds to approve the parking variance to allow for full occupancy of that building per the code. So I think as we identified here that it would be 40 fewer parking spaces that are serving on site for this facility in its current configuration. In staff's review of the application materials, we don't believe that the variance findings have been met. We did not find evidence to really support any of the findings, but principally we're focused first and foremost on the reasonable return standard. How can you show that you have a hardship, that there's no reasonable use of this property for a use that's allowed under this zoning district? Now, narrowly allowed in this case because of the special use permit, it's for senior housing or independent senior living facility. In the application materials from the applicant, for the most part, and they'll be able to speak to this, they'll argue that the site's been used without the city's knowledge, or at least not full knowledge by the city, as regular apartment dwellings, not as senior housing. We can't vouch for how long it has been used and rented as non-senior housing. We know it is right now. We've been in that conversation for a while. That's why the applicant's here. We know they aren't doing it. They know they need to do it, so they're trying to find a remedy to that situation. But as we look at this, again, what's the allowable use in the zone as senior housing? The evidence in the record doesn't demonstrate that it can't be used for senior housing. The evidence in the record says the applicant would prefer to rent it to low-income housing because they believe there's a greater need. Desirability, higher profit, none of those meet the statutory requirements for a variance in Iowa. So staff, unfortunately, isn't able to make those findings based on that kind of evidence that's in the record. So staff is recommending denial of the variance due to the lack of evidence supporting the variance findings. And I'll be happy to answer any questions from the board.
Thank you. Are there any questions?
I have one.
Okay.
Trip Street, is that parking on both sides or is it only on one side?
I do not know that.
Don't know. Okay. And my second question, you wouldn't know the answer to too. And it would be, could Trip Street absorb an additional 40 parking spaces from this one complex?
So yeah, without knowing the
Yeah.
allowable parking and be able to tell you that between Dotson and Franklin that there's 27 parking spaces or 43. I can't tell you that tonight of
Okay.
what the amount of available on-street parking is.
Other questions? Okay. Now it's time for the applicant to speak to their request.
Good evening, everyone. How are you guys doing?
Good. If you could state your name and address.
Yes, Graham Parr, 1301 East Washington Street, Indianapolis, Indiana, 46202.
Do you swear to tell the truth?
I do.
Thank you.
I just want to start off with just a little bit of background. Kelly, we've gone back and forth, round and round and round, several meetings about how these two properties are two properties, and that's the statement that Kelly's going with. The history of it is a little bit different. And it's the fact that, yes, they were permitted as two separate properties in 2000, I believe it's 2003. In 2004, the state of Iowa ended up awarding tax credits as one property, and there's one LURA across both properties, requiring us to consider them as one property. There's additional issues with HOPA, Fair Housing Act from the federal government. They view things such as shared amenity space, such as the parking. There is a bifurcation of the two from a physical standpoint, but there's nothing restricting someone from parking in the other lot. The only difference from TWG's perspective that this is one versus two properties is how many signs are out front. For Windsor Point, that was the developer before us that actually put the deal together, did not run this as two separate properties. They had one management office. They had one set of books. It was only ever one project from their perspective as well. The difference from the special use of the seniors only, the situation on how we're here today is kind of arisen by the fact that there was an issue with leasing this up to seniors. Four Windsor was not able to lease it up to seniors, and therefore they went back to the state to get an exemption, and thus the LURA from the state of Iowa or the Iowa Finance Authority. If you guys have any questions, feel free to ask afterwards. I don't know where everyone's understanding is on that, so I try to go a little bit deeper in detail. So we basically have the 7 12-unit buildings on the west side. We all understand that those are fine to go. On the east side, we have the 161-unit building, and that's where the issues are caused. For us, it has always been, we've purchased both properties as one management set. So we don't see it as two different sets of buildings. It is one property as a whole. The entire time that we've been managing it, it has been only one set. There's only been one management team, one leasing officer, there's one leasing office. Going with the variance, as far as all of the different standards that we have to meet, the granting of the variance shall not be contrary to the public interest. It's almost impossible to prove a negative. In fact, I think it's actually possible to prove a negative. But by not granting a variance, we would actually have some significant issues going against the public interest. The fact that we would actually have to vacate all the residents that are in that building that would not qualify under the special use permit in and of itself should be against the public interest. We've got the land in question cannot yield a reasonable return if used only for proposed use or a proposed purpose, allowed in the zone. We've already seen a developer do that, and it didn't work. That's why they went back to the state and got the additional LURA on the land. The plight of the owners is due to unique circumstances and not to the general conditions of the neighborhood. I think we're the only person, that was a smart ass remark, I'm sorry, but we're the only ones here today for a reason, right? This is not something that's normal. This is not something that is in the normal situation. It's a unique circumstance. I think that one's pretty well checked as well. And the use of the use to be authorized by the variance will not alter the essential character of the locality. Kelly's already said that there are 61 people in that building that most of them do not meet the special use variance or the special use permit that we've seen. So by not granting the variance, we're actually going to see it change the character of the locality. Spirit of the ordinance shall be observed even when the variance is granted. I don't have a good argument for that one. I'm going to be honest. And there is a good comeback that I have, and that is we are more than happy to go through the PUD process that Kelly has offered through the city. This is much more of a timing issue. This is not a combative situation, in my opinion. TWG doesn't see that. We love working with cities. This is much more along the lines of how do we get this project moving forward and renovated for the residents of this property. Unfortunately, at the end of the year, the QCT map or Qualified Census Tract map changes, and this project loses about 30% of its funding from federal tax credits due to that. If we don't have our approvals from IFA before then, this project, the AC rehab, or just the rehab portion, because we've already acquired it, does not become financially viable to create this new value in the community. So the spirit of the ordinance is actually upheld of creating sustainable living or affordable living through this. Substantial justice shall be done as a result of granting the variance. I don't know if Ames has an actual legal definition of justice. I would say that keeping people in the houses or the housing they've been in for 10 plus years is a rather noble goal. Generally, TWG feels that we meet all of the standards that Ames has, the city of Ames has for the granting of a variance. We don't want to feel like we've bamboozled anybody. And that's why I would like to put forward that the variance be granted on a conditional basis, that If in 60 days we have not applied for the PUD process, that the variance can be withdrawn. And we can continue to go through the PUD process, but by granting the variance tonight, we would be able to start the process with IFA immediately to continue with the tax credit funding. Once the PUD process actually resolves, we would then be able, the variance becomes null and void essentially. It's a different zone. And so we feel like this is really a great way. It's not a combative situation. It's us coming to the table, figuring out how best to bring this investment to the community, to you guys. So with that, if you have any questions, feel free to ask.
Thank you. Are there questions for the applicant?
Yes. Sorry, I have a whole list of questions.
Go for it.
When did TWG buy their properties?
Yes. I think I have the exact.
They're
date.
legally two properties in terms of
So there are
land.
legally two parcels.
in terms of parcels.
Yeah.
All the apartments were converted to condominiums,
Mhm.
so legally they're actually more than one property.
Got it.
More than just each building is a
Each
separate
building.
property.
Got it.
I think it was October of last year.
Yeah, that was what I
Fall of
had.
last year, I believe, is when we
Yes.
first were looking at it.
When you purchased the properties?
I don't remember what day the financial close was.
Yeah, but last year. at some
yes,
point.
it was end of last year.
Recently.
Yes.
Okay.
This is October 2020 here.
Question is, who did your title opinion before you did the purchase? 'Cause
Well, I'm gonna guess it was Iowa Title Guarantee because
they don't do the title opinions.
No,
They only issue the certificate, so.
So, how long was it actually used as a 55 plus facility?
How long was it only rented there to 55 plus?
Correct.
Based off the timing that I've seen, it was placed in service 2002 or 2003,
Mhm.
and the Lura came in early 2004, I believe. So it was pretty quick when they realized that they weren't going to be able to lease it up. When you have senior living, a lot of the times we have situations where people are wanting to get in to these senior facilities, and so you can see pre-leasing schedules. And then in the first 3 months, if you don't have a whole lot of action on those schedules or the lease ups, you know whether or not it's going to be, successful.
Okay. And did you say that it's being used for affordable housing, or is that all of it is?
It's not right now.
It's okay.
I think it's all market rate right now.
Okay.
That was my understanding. What we're looking to do is put it back into the affordable housing system with the ACC rehab.
Is that a requirement of the tax credits that you're going after?
Yes. So it's a 4% tax credit ACC rehab program.
So that you would have to provide affordable housing if you
Yes.
apply for that.
Yes.
It's a requirement. Okay. And can you explain the PUD process and like how that would?
That's probably a staff.
That's
Sorry.
Yeah,
I
that
will
was
ask that.
something.
I will ask that when we go back to you.
I would love to find out. No, I'm just kidding.
Okay, that's all the questions that I went through my list.
You,
Actually answered mine.
yeah, you contacted the city before you purchased it though and got a zoning confirmation letter that was for senior housing.
I don't know.
Staff report says.
Yeah.
September 1st, 2020. Got a zoning confirmation letter that it was for senior living prior to purchase.
I mean, if that's what staff has as
Yeah.
the date, I don't know for sure what the dates were
Okay.
on it.
Other questions? Okay,
Okay.
we'll come back to you.
Thank you.
I will open the public hearing. Are there any members of the public who wish to speak to this request? You can come up. Okay. State your name and address, please.
Jody Stumbo, and I am the president and CEO of the Bridge Home here in town at 225 South Kellogg.
Okay. Do
We
you swear to tell the
provide-
truth?
What?
Do you swear to tell the truth?
I do.
Thank you.
If you are not familiar with us, we are the only organization in Ames, Story County, and actually a Two Rivers, 5-county region that provides homeless prevention, homeless shelter, and housing programs for people that are either experiencing homelessness or on the verge of experiencing homelessness. And I am here tonight to ask you to maybe take 2 steps back from your role as enforcing zonings. I recognize we need this in our community, keeps people safe, it keeps things constant. I understand the reason for it and the reason for this discussion. But I don't know if you understand what's going to happen if this cannot be affordable housing. So one, both the city and the county have recently done studies, and it has been loud and clear that we need more affordable housing for multifamily units in our community. Our families are in bad shape. And I can tell you the impact of COVID is now even hitting us harder. Within a 2-week time, we had 6 families come to us who are homeless, a total of 25 people who are homeless, families in our city that cannot find any affordable housing to live in because it's not out there. So to me, if we got a chance to have this as affordable housing for families, and it's been operating that way in some shape, why would we displace these families? Because they are going to end up on my doorstep. And in a time when COVID is already pushing people out of their doors with nowhere to go, it seems to me when we've got something that hasn't been causing problems, hasn't been causing issues, it's been established in the neighborhood for many years, why would we pull the rug out from under these families now, knowing we do not have 61 affordable housing units for families to go to. We can't meet the need we have right now. And I'm very concerned about that because should that happen, we do not have the capacity to work with these 61 folks, these 61 households. We're bursting at the seams with what we have normally and with the COVID impact. So I would just like all of you to, maybe step back from the rules and the zoning and whatever confusion happened between the previous people, the current selling, and think about our community and think about what it's going to do not only to the families that live there, but to everybody else in our community. Because homelessness affects each and every one of us. If those 61 households end up on the street, and that number of 25 that I told you we've had in just a couple weeks, one individual on the street costs our community $40,000 a year. These folks are housed. We should not pull the rug out from under them. And thank you for a chance to share with you the impact that this really could have.
Thank you.
Don't run off. I have a question.
Okay.
I don't know if we do.
I'm happy to answer questions.
Do we do questions of the public during the public hearing, or is it just for comments?
I would say this is for comments. And evidence is presented by the applicant and by staff. It's not
Yeah.
presented by.
Well, she's more of an expert speaker on a lot of homelessness and,
I wouldn't consider that one of the
okay,
standards
Yeah.
for variance.
all right.
Sorry.
I'll ask her afterwards.
Okay.
I'll
Thank
wait
you.
around a little.
Other members of the public who wish to speak to this request, come on up. Oh.
Okay.
Name and address, please.
Hi, good evening. My name is Linda Munden, 209 East 6th Street. Here names?
And do you swear to tell the truth?
I certainly do. Thank you.
Thank you.
Yeah, again, I live here in Ames, and I live down on 6th Street, which isn't the rich part of town. It's over by Banshell, and a lot of low-income families live down by me, and they're really struggling. And I'm next to being a senior myself. I'm 61, so it's not going to be be too long before, I'll be in that age group. Maybe I already am. I don't know what the age cutoff is for moving into senior apartments. So, I'm certainly not one to say this, seniors shouldn't have a place to live in our community, but I don't know that I would want to be tilted toward, if you're a senior, this is where you need to go live. So, but I do know that there are a lot of families in our community who are struggling to try to find affordable housing. When we look at what is out there on the market, and it's all rent by bedroom, $500 a month per bedroom, and it's all geared toward our young students who do need a place to live, and that seems works out for them, even though a lot of them are going in hawk with student loans so that they can live there. But that's another matter, and not for our purposes here tonight. And I'm certainly not so concerned about property management companies making money. So that's not why I'm here tonight either. But I don't want to see families get displaced. I know that there are a lot more families in our community who are trying to survive under that 30% AMI than anybody really realizes, I think, and especially even under that 50% AMI. So I think that what the gentleman here with us tonight said, it's who's it going to hurt if we take that 60 days with a temporary variance, take time, think about it, work together, give them a chance to work with IFA and get this done, so that I know that if we put our heads together as a community and really set our minds to it, that we can solve this problem, we can solve worry about that parking issue. I understand. I'm a rule follower. Anyone who knows about me knows I'm a rule follower, and I understand why zoning is in place. I understand why it is. It's pretty strict, though, and I think that we can work around it as a community and keep these people housed. Let it become the housing that we need in our community. I really think so. I thank you for your work and for serving our community. And please be thoughtful when you make your decision.
Thank you.
Thank you.
Here's my cards.
Okay, seeing no other members of the public, I will close the public hearing. Now it's time for questions of the applicant and staff again.
To answer Ron's question about Tripp Street parking, our ordinance for Tripp Street is that parking is prohibited at all times on the south side.
So the north side of the street is public parking.
Okay.
Thank you. Under city code, are we allowed to condition a variance on time frame? Usually there'd be a provision on the variance section that says you can sunset a variance, but sometimes there's not.
It's not addressed in the municipal code. I don't know that Jane and I have discussed how that would work. I'm not experienced with doing that.
Okay.
I'm not sure what to make of that exactly.
Yeah, I guess, would you be able to even get to the findings to allow for a variance?
Right.
Is my question.
Right.
Yeah, I think does duration change the ultimate findings? I guess that's the question that I don't have a handle on, really, because if the findings are valid for 60 days, are they not valid for 70 days or 90 days or 10 years or forever? That would be the case that I guess that's what I would be asking the board, is how do you distinguish for a time period?
Okay.
But
So-
the code doesn't really say one way or the other, and I'm not familiar with it from a case law perspective, unless you are, Jane.
I am not. I haven't looked into that.
And I would
Okay.
say, and we've heard some testimony about if it's denied, what's going to happen. The board is not involved in code enforcement. Code enforcement is stayed at this point because the applicant's seeking approval and relief to avoid going through the code enforcement process. You should not really worry about how the city does code enforcement. That's a separate policy administered by the inspections division, and it's not like we're going to seek immediate enforcement tomorrow and force eviction somehow on properties. I can't tell you how it would go right now because we haven't approached it. We're looking at how to solve the problem and make it workable for TWG. But code enforcement itself is not really part of the findings for the variance.
Other questions for staff?
So I guess you already said that it's not really up to us, but if they're saying that they need 60 days to go through this other process to make sure that there are within the code.
I think they said they need approval. They need like zoning conformance to go through that process.
So, yeah,
That's-
so we did the 60 days is new to me tonight. So just to kind of
Yeah.
explain what we've laid out, I think it goes to your PUD question is how this relates to that request.
Yep.
So as the applicant stated, the rules of the game change on January 1st in terms of how to get funding for the rehab project. And we have just over 60 days left in this year. The process outside of a variance that could accommodate the request, it goes through the Planning and Zoning Commission and through the City Council, is to add a planned unit development overlay to the base zone. And what that does is a PUD allows for council to allow for some deviations to certain standards in recognition of some other trade-offs with the project. One of the elements of a PUD that can justify deviations is affordable housing. And it just so happens that the way the PUD ordinance is written, the allowances related to parking can meet code under the PUD. So that 40 space variance component, they would have the way that is worked out in the PUD ordinance is that council can waive a certain number of spaces related to affordable housing units that are 3 bedrooms or more. And there's, I believe, 36 3-bedroom units combined across the 2 properties. So what has to happen is it technically has to become viewed as one community, just as the applicant is portraying it now. And if city council rezones both parts, say it's an integrated site, then the parking can be blended across the site. So it can meet code for parking if city council accepts that commitment for affordable housing. That process, because it has to go through 2 public hearings, as I've discussed with them, it's probably safely a 60-day process.
Okay.
So even if they start right now, they're looking at trying to rush it through to get it done by the end of the year. And at the same time, as they've told us, and I think they said tonight, they would like to get processing it quicker with IFA themselves because they don't know how long it take IFA to process the paperwork. And that's so that's the outline that we've given. We're not involved in the IFA process. Clearly, we didn't sign the paperwork that said it can't be senior housing in the first place. So the state processes, the state rules, that's not really something that we're normally involved in. And we can only answer how our local ordinances apply to the projects.
So do they need a variance to start going through that process?
We will not, as staff, sign a form that tells IFA it complies with standards. And that's what generated this process in the first place, was IFA asking us to sign a form that said it complies with zoning standards, which we cannot do because it does not.
But it would if they go through the process.
If city council changes
If
the zone, so if the council changes the standards, that's different. But
But
in the
they
base
can't-
zone, as it stands today, they do not comply.
So it's kind of they're at a standstill. They can't go after the process if they can't get a variance, but they can't get the variance without. it
But it's
being-
not about getting a variance. It's do you meet the findings
Right, you
for
don't meet the
variance, right?
findings.
It's so
That's
it's 2 different, totally different processes.
Yeah,
The PUD
yeah.
is what's a general welfare kind of evaluation tool versus this is a hard and fast, does it meet the law or not meet the law tool?
Other
Okay.
questions for staff or?
Oh, I have some questions,
Okay.
please. So would we be in this situation if the property hadn't changed hands? Would the staff would notice, hey, they're not using it like it was supposed to be? And
I mean, it's hard to say. If someone had brought it to our attention and we followed through, we would get to the same point. If the prior owner wanted to refinance and wanted us to sign a form, we'd be in the same position. But no one had. So we normally respond to complaints about zoning conformance. That's how the city responds to issues like this. So I've been here for 8 years and I had never fielded a complaint that said this was built as senior housing and there's no seniors living here. So we did not have knowledge to go enforce that since I've been here. And that's how we respond to almost every complaint in the city is for
so
enforcement.
would you say that the current owner is in a position that's not his doing?
I would not say that because they bought it eyes wide open, knowing it was not in compliance.
Knowing that it was?
That zoning verification letter includes the special use permit. that says this is for senior housing only.
Okay.
Yeah.
And then Ray has been in correspondence back and forth. Ray Anderson, the other planner, has been in correspondence back and forth with TWG about how that works, what complies, what doesn't. So no, I think
Was that before they purchased or after
So
they
the-
purchased?
it doesn't really matter. It's their due diligence.
Okay.
We gave them the permit. It doesn't matter if you even asked for this letter. It's your due diligence as a property to understand the law that applies to you. It's not our job to tell every owner, here's the disclosure about what laws apply to you. So they acquired it. In this case, we do know that they had the zoning verification letter. They had forewarning that a special use permit applies to the property. I don't think they looked into it very far until later when they're looking at the refinancing issues.
And that would be through the title opinion process of purchasing.
I'm not involved in title opinions, so
Okay.
I can't answer that.
All right.
It's-
A zoning verification letter is basically a public records request. That's all it is. What can you tell me about the city permitting history on this property?
It's on page 2, paragraph 2.
Yeah, so there's no opinions offered by us about things. It's just, here's the list of standards, here's the list of permits. Take it and work with it as you want.
Kelly, was there a discussion at all about adding parking to this site at all?
So initially, when the applicant started trying to see how they could address this, they did show us a site plan that would add some parking in the circle in front of, so this circle right here, they had a way to add some parking. They can't add 40. And our advice to them was adding some, since it doesn't get you to the 40, actually triggers a third variance. And it didn't seem like any justification to get partially more parking was really going to carry the day for the argument. So we suggested don't ask for a third variance to add more front yard parking and remove landscaping. We said just go forward this way. If you get the senior approval and there's a concern about the 40, then maybe there's a reason to pursue that separately. But in our eyes, the adding a third variance to the table didn't seem to make the argument better. So they chose not to apply for that. Yeah, there's no way to add 40 spaces anywhere between, even if you combined all of the properties, there's no room for 40 more spaces here.
So even if
Unless you did away with the pond, but then that's probably another can of worms.
Yeah, I guess if you were to underground the stormwater facility, but at that point, you're getting into a pretty substantial issue with a regional detention facility that I don't think anybody wants to tackle.
Okay. Other questions?
One more, and this could be for her, or it could be for you. Can we approve a variance with a sunset clause?
I mean, I think, I'd rather recess for a minute and talk to Jane about what that means than give a spot answer if that's really something that we're looking at.
Yeah, and I think what staff's answer was before was that we need to go through the findings and determine if the sunset clause means that all the findings are met. I don't know if it would have an impact.
Okay.
And I don't know, again, we didn't talk this through with the applicant before tonight, so it's a little new to me. What, am I signing a form to IFA that says this is legal for 60 days? I don't know what that means. If that helps, if you granted that and that's the form I had to sign and IFA likes it, that's IFA's issue, I guess. It's not mine.
So if you were to combine both properties, would there be enough parking? Does the adjacent property have excess parking?
Only under the PUD, because the PUD allows council to lower the parking requirement because there's affordable housing.
Got it. But not under the standard rules that apply.
Correct. The only parking reduction allowed anywhere in the code is through the PUD for
Okay.
affordable housing. Market rate housing is not permitted to have a parking reduction.
And the lot next door has just enough for themselves.
Yeah, so each site,
Don't
as
have
I
any
understand it,
surplus parking
meets
for-
minimum parking requirements as approved.
So Kelly, I'm going to ask you,
There might be one or two
Yeah, that's
spaces.
not significant surplus.
I'm going to ask you what's probably a fairly difficult question, I think, but it's a question that's hanging out there, I think, because it was brought forward by one of the witnesses or one of the people who testified, and I think it's an area that falls under your purview. Ames has the topic of affordable housing has been something that's been before the city for years now. And it's been in this very neighborhood area, down around the old middle school area and things like that. Has been something that has been brought before council time and time and time again to try and bring more affordable housing. We heard a fairly impassioned plea that if we don't do something about this, we're basically going to be not standing up for affordable housing, paraphrasing. But I think that's a pretty close thing of what Jody would say to us. What's your response to that as the director of a department that also, I think, oversees housing? Or
So
can you help us out with this a little bit? We were a pretty impassioned plea, and
So
what do we say to that?
So I don't disagree with the housing assessment to say we're not able to provide and the market doesn't provide enough affordable housing for low and very low income households in Ames. And I can't argue that. I don't want to argue that. I agree with that. The distinction here is that you can't contravene the zoning with a preferred use. So it's really an issue that's a policy question that city council is meant to grapple with. So yes, we are building affordable housing down the street. We haven't heard word yet if our 37 unit affordable apartment project is being funded by the state. We have some ownership homes that we'll have as affordable housing down the street also. We just don't have word on that. I mean, it doesn't in any way approach the need. It's just a project that helps address some people's needs. And for us in the variance, it's really, does it meet the standards versus the policy question of council. So through a zoning standard or through a land use policy plan change, that's where the council addresses it from a policy perspective.
And it might also help your decision-making for Kelly to give a little more background on the timing of everything. When the variance request was made, when discussions with planning started regarding the PUD.
Yeah, so one thing that did happen to the applicant in the spring when we first started discussing how could they get to what they want, the PUD ordinance didn't exist. The city council adopted the PUD ordinance. I think it went into effect at the end of June. And it was later this summer, before the August meeting, but later in the middle of summer is when we identified that maybe that was a better option before that August meeting. The applicant didn't pursue it at that time. I think after the August meeting, Ray and I had another conversation explaining this might be the better avenue forward in probably around Labor Day. And the applicant chose to move forward with the variance request. As they said, they saw it as the most expedient option in front of them at that time. So the options did get adjusted in the middle of the discussion when council adopted the PUD ordinance in the summer.
And at this point, has an application been submitted for a PUD?
No, it has not.
If there are no other questions for staff, we can have more questions of the applicant. I have a few. Okay. Could you come back up, please? So could you describe again, what is the current use of the property? I thought you said it was market rate right now.
No, it was my mistake. The reason why I said that was a lot of the times LURAs are 15 years. And so based off of the time of the LURA, it would have timed out in 2019, but it was actually extended. So it is currently affordable housing.
Okay.
Yep, that was my mistake there.
Okay. And when the new QCT map comes out, what's the result again?
Well,
What's
so the new
reduction?
QCT map is out. It's just effective on January 1st. And does everyone understand how QCTs, like what that measures? Yes.
No, they don't.
Okay.
No.
That's why I ask. Essentially, it is the Census Bureau saying this section here has lower incomes than the non-qualified census tracts. So qualified census tracts are lower incomes than normal census tracts or non-qualified census tracts. By being, it's HUD has a very nice website where it turns the census tracts purple. By being in the purple area, you're in a qualified census tract. And that means that you can get this 30% boost of the federal tax credits for your property through IFA. The IRS pushes it down to the states to actually divvy that stuff up, though.
A 30% boost, but without being in qualified census tract, there's still a tax credit.
There's still tax credits. We've seen a lot of cost increases. Maybe in 2019, we were able to get deals done without the QCT. I get calls 2 or 3 times a week of, hey, here's this property. What do you think? And the first thing I do is I can check it out on HUD to see whether it's in a QCT, because if it's not in a QCT, the costs don't work out. So it's not financially feasible.
So you're saying the costs don't work out in this case?
On January 1.
On January 1. Okay. Thanks.
Yep.
Other questions for the applicant?
Does the security door on that building work now?
I would say so.
Okay.
I was talking to our management team last night, and they said that things were looking good over there.
Okay.
I don't have an answer though.
All right.
So what happens after January 1 if you guys can't go after the?
It's not good. It honestly comes down to evaluating what the best circumstances are. We don't really have an option besides to remove everyone that's in the building. Just because we need to stay compliant with the federal or Fair Housing Act, as well as Ames city code. And so the only way to do that would to be actually remove everyone that isn't compliant under Ames city code. And that would be the eviction of several dozens of people.
I might have another question for staff about that, but other questions for the applicant? Okay, thank you.
All right, thank you.
Jane, would you allow any late public comments?
We'd have to reopen the public hearing. I can take a motion for that.
I'll make a motion to reopen.
I'll second.
All those in favor?
Oh, no. Aye.
Aye.
Opposed, same sign. Okay,
I appreciate that. In my defense, I was here at the last meeting. I was the first one here, and the applicant didn't show up, and I apologize for being late, and I won't belabor this. I'm Eric Eadie.
yeah.
I'm an attorney here in Ames at the Nye Master Law Office.
Do you swear to tell the truth, and could you add your address?
I do swear to tell the truth. My address, 1416 Buckeye Avenue, Suite 200 would be the work address. Here in
Okay.
Ames.
And then could you complete an orange information card before you leave and give it to Renee, please?
Sure.
Thank you.
You bet. And I'm here today on behalf of Jensen 5 LC, which would be the landowner that's pretty much to the south of the subject property. And I got to confess, I served on this board, not in Ames, but in another town for 15 years. So I know what you guys go through. And I can appreciate the kind of the earnestness you have when you hear all these complaints and problems that, boy, if we can't get this to meet zoning, there's going to be some harsh consequences. And again, this case isn't like, my fence is 2 feet over the neighbor's lot line, or my garage is separated garage is a couple of feet from the rear lot line. What you've got here is a very sophisticated buyer that made a package deal, one of which included this property. And I got to believe that anybody that's doing the kind of due diligence that they're doing, and I think we have evidence that this is the case, knew exactly what they were buying, presumably factored that in to say, hey, we've got this property, we're out of compliance, but they went forward with the deal anyway. Didn't have to, because again, the package deal, I'm going to guess that the purchase price is going to reflect that, the fact that this, property currently is not zoned for its current use and may very well not meet variance requirements, because we're asking for quite a large variance here, quite frankly. And again, if you read the factors that you've got before you, legally to follow, typically with a variance, you're going to find something unique, about the property physically, that lends credence to that request, that there's something so unique about this property that we should be allowed an extra right under the zoning. And that's not the case here. This is just a case, I mean, quite frankly, I think that, you know, when you buy this kind of a property, knowing that you're not in compliance, you got to roll the dice and come here before you. They got nothing to lose. I mean, they knew what they had. They knew what the consequences would be if they didn't get a variance. So really had nothing to lose. And so I guess, you know, just to impress upon you, you know, all the talk about the, you know, the need for low income. I mean, I appreciate that, but really your duty here today is simply look at those factors. Anytime you have a variance request that's denied, it's going to cause problems and hardships, probably for the loser. But this case, again, represents quite an extensive request. And the other one factor that it doesn't come up very often is that the situation is typically not of the applicant's making. That's one of the factors that you're going to have to look at there. And this case gives you a very good example of where that's the case, where, again, cards are on the table. I mean, you could kind of look at the property. When I went and looked, I thought, well, it kind of looks like might be, you know, for senior living or something like that. But these people, again, went way farther than that. They did what they should have done. They got the letter from the city. They knew exactly what they got. And I would just urge you on behalf of, a very concerned neighbor, besides the other issues about parking. I mean, there's a reason why this was developed the way it was. And, you know, to break that down, even though the fact that, you know, it might have gone for years with a different use, doesn't alter the fact that, you know, if you're going to ask for a variance, you got to meet those requirements. And in this case, it's too big of an ask. So, thank you.
Thank you. Okay, I will close the public hearing. Other questions for staff or the applicant? Okay. I just wanted to confirm with staff that basically, as long as they've been going through this variance process, you haven't taken code enforcement action. And
Yeah.
so would it be likely that if they're going through the PUD process, you're not going to be taking code enforcement action while they're going through that process either?
Yeah, so typical code enforcement policy is when you've been notified that you don't meet code, and we haven't even issued a citation for it. We're trying to work through this as a zoning compliance issue. What we typically do is if someone essentially files an appeal, and you've had appeals of my decisions before, that stays the action. Plus code enforcement works on a plan for remedying the situation frequently with property owners, from, you know, anything from brush removal to whatever issues out there. They work with them to get a schedule for compliance. So yeah, no citations been issued. We've been waiting to see if we can get resolution one way or the other before we went through that process.
Thanks.
But they can't go after the PUD without the variance, or is
No,
that not
they're
true?
That's not true.
independent.
That's not
They're
true.
unrelated.
Okay, so they can still go after the PUD,
Mhm.
whether the variance is approved or not.
And so
Correct.
the question is, can they get the PUD by January 1?
Right, but
I
that
think-
doesn't matter if whether we
I think
approve
that,
No.
the variance or not.
yeah, so the city process, based on a timely application, can be completed by the end of the year. I don't know how IFA is going to do their paperwork, but again, I'm not sure how a policy decision of the city council relates to the findings of a variance. I've never heard anybody get a variance for a process. That's essentially what's being suggested. I can't go through this process fast enough, so I want this one. And again, the 60 days, I'm just not familiar with that option.
Do we know what was the deadline for the
Planning and zoning.
Iowa title
We can
or
ask the
Iowa
app-
Finance
we can ask
Authority?
the applicant.
Okay. Yes.
Could you
Well-
come back up?
Just a quick,
Sorry, I just want to make sure the mic picks it up.
what is the deadline with Iowa Finance Authority for the,
Iowa Finance Authority is very tight-fisted about exactly what their deadlines are. If we can get the 7B signed by the city by the 1st of December, they've said that they can get it done. A couple of days here and there, I'm sure that they can push it through. Unfortunately, there's the holidays at the end of the year. Unfortunately, as far as business goes, I love taking the vacation time, but that does tighten things up from that perspective. I have seen IFA on one of my other projects push it through in as little as 2 weeks, but that was with almost weekly or daily calls to them. But there is no specific deadline. They have said they would be willing to work with us, though.
but that is a concern right now.
Very large concern, yes.
Okay.
Thanks. If there's no other questions, we can have a motion. Discussion. I will just throw it out there that, and I know this doesn't really relate to the findings, but the PUD sounds like a better option because then there's a commitment to affordable housing with the city, whereas they can't go back to market rate. And it's really a more legislative process that they should be going through to get that commitment and offset of parking and other requirements because of that.
So make your motion, ma'am.
I agree.
Then we can discuss.
Okay. I don't usually make the motions.
You can.
I don't know if you guys can make motions, let me know to speak again.
I think we've moved on to
Yeah.
discussion, unfortunately,
Okay, that's fine.
but thank you. I would move. Oh, I can't find the alternatives page. I'm sorry, guys. 5. Alternative 1, denial.
I'll second the motion.
Okay, so it's a motion by Schoeneman, a second by Schneider. We can have discussion.
So if we deny the motion, they're able to go through the PUD process, which is the process that they're planning on going
Yeah.
after regardless of if we approve it or not. Because approval, they're requesting approval just to be able to have enough time to complete the PUD process,
Right.
as I understand it. Do you guys understand it the same way?
Yes. Yes.
So it doesn't matter whether the variance is approved or not. The PUD process is really what's needed to
Yeah. And they could
make the
accomplish-
site compliant.
They could make the site compliant through a variance. I just have major concerns about using the variance as a variance to a use, whereas we have other
Right.
tools in the zoning code that would be more appropriate and get a better commitment for affordable housing, which is clearly needed.
And the applicant basically requested that the variance is only for a certain amount of time so that they can complete the PUD, but we here agree that the variance is not needed to complete the PUD.
No.
Well, and
We agree
I don't-
that the PUD is the way to go, and
I
we
don't know how we can
think
find a finding of fact either. I mean,
we probably can.
It's just a bridge too far.
Yeah.
it's too far. Not to argue against the affordable housing. I mean, I think already went out on that limb.
Yeah.
I understand the affordable housing issue and I'm supportive of that, but we can't find facts that aren't there, and we can't use authorities that we don't have.
Like I
Yep.
said, they're not even, I mean, if it was close, you could look at some of those factors maybe, but based on the number of units alone,
And I don't think it's, I don't think it's a factor of this that would be the issue of causing an affordable housing crisis if there even were to be one that were to result from this. And I don't think that there has to be an affordable housing crisis from this either. Let me say that right now, that I don't think there has to be an affordable housing crisis from this.
Yeah.
But even if there were, I don't think it would be because of the lack of a variance.
I
The
mean,
lack of finding a fact. The finding of fact is,
yeah.
well, if they,
Other discussion?
There is a Supreme Court case I found interesting that a variance board approved thing. Another owner took it to the district court, got overturned. Then they went to Supreme Court and the Supreme Court upheld the variance board.
right, that doesn't,
Yeah.
district courts don't get it right all the time, do they?
I will read what can happen in 30 days after we take a vote.
Right. Yeah.
So,
I don't. Yeah, the factor of whether they can apply for the PUD should not matter. But it's out there, so
yeah. Well, and what it comes down to especially is that the findings aren't met. Unique circumstance. It seems pretty self-inflicted, and I've got concerns about rewriting findings in this case, especially because it doesn't seem like that unique of a circumstance when folks have zoning conformance letters and then need a variance to a use that they knew wasn't allowed and come to the ZBA for that. And we've got this precedence.
that, or just because that was used in non-conformity, just because you're speeding and the other guy is speeding doesn't mean you can't get stopped for speeding.
Yeah, just because
So
Okay. No further discussion. We can have a roll call vote.
Aye.
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 Nay.
aye.
Okay, the motion is declared approved. Any person desiring to appeal this decision to a court of record may do so within 30 days after the filing of this decision. There are no other items on the agenda? Motion to adjourn?
Second it.
All those in favor?
Aye.
Aye. Opposed, same sign. The meeting is adjourned. Thank you, everyone.